All right, welcome back. So we said that the adjudication of constitutional issues can be granted to something else in the superior court, which has, again, the default power to do that pursuant to Section 96 of the Constitution. And that could be either a court, for example, the federal court, or an administrative tribunal. So administrative tribunal can be given the ability to adjudicate shorter issues, again, subject to judicial review to the extent that, as I said, you can always eventually get to a court to say that the decision was wrong, but can be given the initial power to make that decision. That's a significant narrowing of the scope of the jurisdiction of the courts, right? So for example, if you have a tribunal being given the ability to adjudicate car accidents, for instance, right? Again, we're no longer looking at specifically federal areas of jurisdiction. That's why I gave you another example earlier. I said the patent board that makes decisions on patent issues. Now we're back to more general issues of administrative law. So the government, whichever government it is, federal or provincial, creates the car accident tribunal to make decisions on car accidents. Then initial issues as to the interpretation of whatever the act is, the Car Accident Act, are going to be made by that tribunal instead of the superior court. If you did not have that tribunal, you'd go to the default place the Constitution says you have to go, and that is, as we said way too many times, the superior court. Then government says you have to go to that tribunal instead. And so you don't go to the superior court. Say that one section or multiple sections of the Car Accident Act are in fact unconstitutional. It would be bad if the administrative decision maker did not have the power to decide a constitutional issue there, because it would mean that it would be very unlikely for that issue to be raised. Because if you have a car accident, in the context of your car accident, you go to the Car Accident Tribunal. Then you'd have to also go to the superior court to say, hey, by the way, I don't think the Car Accident Act is constitutional, and therefore I think it should be invalidated. It's very unlikely that you'll do that because it duplicates the cost. And on top of that, you don't really have an interest to invalidate the law as much as you have an interest to get compensation pursuant to it. So say, for instance, your claim is that it's unconstitutional because it limits your compensation too much, right? Then you certainly have an interest to have it invalidated, but you have a stronger interest in getting compensation in the first place, and so you'll most likely go to the Car Accident Tribunal only. Therefore, it would be very unlikely for the Car Accident Act to be found to be unconstitutional, even though it is. Conceptually, it's invalid by virtue of the fact that it was passed, right? Because as soon as it was passed, even before a court or some other body decides that, it's not consistent with the Constitution. It was never valid to start with. And in fact, when a court makes that determination, eventually it merely declares it to be invalid when it always was. That's the remedy. It's invalid to the extent of the inconsistency. Therefore, we want administrative tribunals to have the ability to adjudicate constitutional issues in some circumstances, and especially in the circumstance of applying their own law. So for instance, in my example, the Car Accident Tribunal applies the Car Accident Act. We really want that tribunal to have the ability to assess whether or not the act that it's applying all day, that it was created to apply, in fact, is indeed constitutional or not. And you have the tests for how we assess that, right? And it depends on whether or not we have explicit or implicit jurisdiction. And explicit is somewhat misleading there because generally it's going to be by virtue of a general grant of jurisdiction, not a specific one. So for instance, the law that creates the car accident tribunal and therefore determines its power is not specifically going to say we give the tribunal the specific power to adjudicate the constitutional validity of the Car Accident Act. The statute would not say that, and it wouldn't have to say that for the car tribunal to have the ability to make that decision. If it says that it has the ability to assess, right, its consistency or to apply or refer to any law, for instance, it's generally what the grant of jurisdiction is going to say. That is a broad enough phrase to encompass the Constitution, because the Constitution is a law, of course, right? And therefore, that is what we would count as an explicit jurisdiction, even though the grant of jurisdiction does not explicitly talk about constitutional issues. It talks about any law, but that includes the Constitution. Therefore, the way we interpret that is as specifically giving the tribunal the ability to adjudicate an issue under the charter. So, for example, the tribunal would have the ability to decide whether it's the law that constitutes it is consistent with either the Constitution or the charter. There's also implicit jurisdiction, where you can have some different wording that is far less broad, but nonetheless have an ability on the part of the tribunal to make a decision as to a constitutional/charter issue. And that's by virtue of an assessment, as we'll see, of the role of the tribunal. We'll assess basically in some other way the intent of the government, which also governs. So if the government says any law, clearly the government intends for the tribunal to have a broad power, and therefore when we interpret that as including the Constitution, we respect the intent of the government for that to be construed broadly when the government used a broad phrase. We also assess the intent of the government when it's implied. So we're going to assess the general scheme and the powers of the tribunal to see whether or not they also imply the ability to adjudicate a constitutional issue. And we're doing an exercise that has a similar function there, because we're assessing, again, the intent of the government, right? The government decided how that tribunal exists, so it created the contours of its powers, of its jurisdiction, of its procedure, all the things that are provided for in the law that constitutes it, and therefore, right, that suggests an intent for the tribunal to have a power that is broad or that is less broad. We'll get back to the test for that because the author of the book decided to put it in that order, even though it doesn't make all that much sense. So the remedy that an administrative decision maker is going to apply is fundamentally different from a court, and that's going to be important to remember. So as I said earlier, conceptually, a law is invalid by virtue of its inconsistency with the Constitution. So for instance, government passes a law, that law is not consistent with the right to life, liberty, and security of the person pursuant to Section 7 of the Charter. The law was never valid because it still infringed upon Section 7 when it was passed, way before a court found that to be true. Because for the court to find that to be true, it has to have a plaintiff, right? It has to have someone show up and say that. And by virtue of the way in which our court system works, it can't just be anyone. It can't just be a smart lawyer who knows that all along. It has to be a plaintiff with a specific interest in the case, therefore someone whose rights have been infringed. It has to be someone who says, my rights to Section 7 have been infringed, and therefore I think that provision or that entire law is invalid. Conceptually, the court declares it to be invalid when it always was. The court just says we had that plaintiff show up, and now we know for a fact that it's not valid, and therefore we declare it to have always been, quote unquote, invalid. Then the court, as a remedy, generally invalidates the law to the extent of the inconsistency. So, Section 24 of the Charter, for instance, gives the power of a court to award damages, but it very rarely does. So when someone goes to court and says, right, gay marriage should be legal, for instance, right? It's not actually the way it happened in Canada. It's the other way around. But someone says that in court. Generally, they don't get damages. Generally, the court is simply going to strike down the law or the provision. For instance, the Carter case with Section 7, right? The person says, if you do not allow me to have medical aid in dying, that infringes upon my Section 7 right for a number of reasons, right? It potentially shortens your life because you have to commit suicide differently. It infringes upon your dignity in deciding when to end your life. It puts your right to Section 7 at play. The court doesn't award damages, doesn't say the government breached your rights to Section 7. Ostensibly did that for a long time, right, between the time that it decided not to have that legal by criminalizing it and the time that someone actually showed up to court to complain about it. Nonetheless, the government doesn't get punished by having to pay money to the people whose rights it infringed. The only thing that happens is that the government has their law struck down. And so it's often not that much help for the plaintiffs. It's more help for the future plaintiffs, right? But that's generally the remedy, even though the court has the power to award damages under Section 24 of the Constitution. An administrative tribunal making a determination as to a law does not do that, and that's very important. So the remedy is different. So in my example, car tribunal finds Section 67 of the Car Accident Act to be invalid because it violates either the Constitution or the Charter, for instance, the right to life, which is a charter. The tribunal does not and cannot invalidate that provision as a court would. And that makes sense, right? Because you don't really want that bureaucrat who's not a lawyer, gets paid $100,000 a year, to be able to invalidate a law instead of the courts and then have that provision struck down for essentially everyone, right? You have a conclusion of more general applicability, right? You only strike down, for instance, the provisions of a law that do infringe upon the rights of the specific plaintiff. You don't strike down the entire law, so it's as narrow as it can be. But once you strike down these provisions, they're struck down for everyone, not just that person. We don't want an administrative decision maker to make that determination for everyone for obvious reasons. And so the administrative decision maker is simply going to decline to apply the provision, not strike it down because it can't. What does that mean? Well, it means that for the individual person that is before that decision maker, it's not going to make much of a difference. Whether or not the provision is struck down or not applied, that doesn't make a difference for you as the plaintiff, right? In both cases, it's as if it didn't apply to you. If it's struck down, it doesn't apply to you and everyone else. If it's just not applied, well, it doesn't apply to you, which is the same for you as the person before the decision maker. However, it's not going to be of value to people who make that claim in the future. Oftentimes, future decision makers are going to take notice of that decision as they can. They can look at it and say, you know, that person made that decision, I might agree. They don't have to, they can, as we'll see. And oftentimes the government's going to take notice, right? The government's going to say, oh, that bureaucrat said our law isn't constitutional. We'll have to kind of deal with that. Second, that determination is not binding, as I said, on future decision makers because it's not a general conclusion. And that's significant because it's also consistent with the more general principles of administrative law. And under administrative law, in fact, the decisions of administrative decision makers are never binding on other decision makers. And so you have, for instance, the car accident tribunal developed its specialized expertise in car accidents. That does not mean that it has to follow its own case law in a way that a court would. And that seems odd, right? It seems odd because if it has expertise, you'd want it to create some body of case law that gets applied over time. But that's not consistent with the other principles of administrative law that we saw. First, an ability to respond to the specific circumstances of the case, right? To be efficient and to be more flexible, and therefore, right, for a decision maker to be able to have more flexibility in what it does. And second, one of the reasons why we want decision makers to have that specialized expertise is specifically because we think that these issues have to be determined on a case-by-case basis, not in a way that's bound by precedent, right? We want to have these decision makers with a specialized expertise so they can make specific decisions in specific cases that are responsive to the specific circumstances of each case. So you have the test I mentioned earlier at page 67 for implied jurisdiction. You don't have to learn it by heart, right? But you look at essentially the context, the breadth of the power that's given to the tribunal. So steps are the statutory mandate of the tribunal and whether or not deciding questions of law is necessary to fulfilling its mandate effectively. In other words, how broad the government wanted its adjudicative power to be. Second, the interaction with the tribunal and other elements of the administrative system. Third, whether the tribunal is adjudicative in nature, same thing as the first, right? Same rationale as the first, and practical considerations, including the tribunal's capacity to consider questions of law. And that is going to determine the jurisdiction of the tribunal by looking at essentially the context, right? These are essentially contextual factors that consider how broad the government wanted the power of the tribunal to be in the first place, how broad the government wanted that jurisdiction to be in the first place, and we will interpret it in a way that's consistent with that. I want to get back to something we mentioned last week regarding the independence of administrative tribunals. So we said administrative tribunals are tricky because they are not independent from the federal government. In fact, they're part of the federal government. So the people who get elected by Canadian citizens during elections pass a law that says we hereby create the Car Tribunal Act. And then the same people who got elected decide who sits on the Car Tribunal. And because it's not a tribunal, it's not a court, can decide that these people don't have life tenure and therefore can be removed if the government's not happy with their work. That does not create the same level of independence as the court has, right, superior court by virtue of the Constitution, that it has from the federal government. And therefore, it is likely to be more prone to political pressures, and therefore to making decisions that don't necessarily protect the fundamental rights of the people before the tribunal as much. For instance, a right to procedural fairness, right, for the tribunal to assess the issues independently in a way that's consistent with, right, procedural protections that we have, and the specific rights of the person in the case, independent from policy or other political considerations. It's one of the reasons why we also don't want that tribunal to make a general determination as to a constitutional issue. That general determination, right, as to whether or not a statute or a provision in a statute is going to be invalidated entirely for all future cases. We want that decision to be made by a tribunal that has the requisite independence from the government, that's not part of the government, and therefore we won't let the administrative tribunal make that general determination. There's a third kind of branch to this, which somewhat reiterates the first, and that is pursuant to the Nova Scotia Workers' Compensation Board precedent, which you have at page 70. And that basically creates a pretty simple presumption, and that is an administrative tribunal generally has the power to assess the constitutional validity of its own statute. So you have a law that creates, for instance, the car accident tribunal. Then we will assume, pursuant to explicit jurisdiction, again, explicit jurisdiction being given by a phrase that's broader, so it's not explicit in that sense. Same thing there. We'll assume that the tribunal has the power, the explicitly granted power, to assess the constitutional validity of the legislative scheme that it is created pursuant to. Only, right? Not make other issues, not determine other constitutional issues, other charter issues, simply that one. And that power, again, is not going to be exclusive, of course, right? It's going to be concurrent because constitutional issues cannot be removed fully from the purview of the Superior Court. And so you could also theoretically go to the Superior Court and say that the Car Accident Act is not valid, and you'd be allowed to do that. So we allow you to make that claim in front of the Car Accident Tribunal instead of the Superior Court for the reasons I mentioned, because it's more efficient, and frankly, you just won't do it otherwise, because you'd have to go to two separate courts to make two separate claims, which would be more expensive. And on top of that, the constitutional claims you wouldn't have much of an incentive to make because they don't really give you anything in terms of, for instance, compensation that you're looking to get in front of the tribunal. However, that does not fully remove, of course, that constitutional issue from the inherent power of the Superior Court. And so you could still go to the Superior Court for the sole purpose of saying that the Car Accident Act is not valid, and you are allowed to do that because the Superior Court retains concurrent jurisdiction. Concurrent meaning shared. And as we said earlier, if that decision is made by the Car Accident Tribunal, that decision is reviewable by the courts because you always have a right for the court, generally Superior Court, could be some other court like the Federal Court, to exercise supervisory power, over the power of an administrative tribunal, and that includes that determination. So administrative tribunal says, right, the Section 67 of the Car Accident Act is constitutionally invalid, therefore I won't apply it. It doesn't say I invalidate it because it can't do that. It says I won't apply it. You can seek judicial review of that. You can go to court and say that is wrong. The Car Accident Tribunal got it wrong. In fact, it is valid. And you're allowed to do that because the court retains, as I said, supervisory jurisdiction. And as we said, that is an issue that is reviewable on a correctness standard. So it is correctness review. We looked at very briefly last week what that means, what correctness versus reasonableness review means. We'll get back to that at the very end of the semester in a lot more detail. But basically, it's a standard that's not deferential, and that assesses whether the court agrees with the decision that's been made or not without giving much leeway or deference to the administrative tribunal. One of the things that you always have to keep in mind when you're talking about constitutional issues is whether the Constitution applies. And it sounds silly, but it's very easy to start assuming that the Charter always applies, and in fact it doesn't. Most of the time, it doesn't apply because the Charter, right, was added in 1982 to the Constitution. It is part of the Constitution. Therefore, it only applies when the Constitution applies, and that is to public action, to action by the government. And so, you cannot have your charter rights infringed by a private party. So a person or a company. You can't say, for instance, your Section 15 right, which says you have a right not to be discriminated against. You can't say that a company or another person infringed upon that right. They might have. But your right just doesn't apply there. They might have discriminated against you. However, you do not have a Section 15 right against these people, because Section 15 is part of the Charter. Charter only applies to public action, and there's no public action there. It's private action. So the Charter applies to the relationship between you and the state, not between you and someone else or some other entity. And most often, right, what that's going to mean is the validity of specific laws, because the main thing that unites you and the state is the laws that are being passed by the state. So what that generally means is that it allows you to have a court or some other adjudicative body make a decision as to whether or not a law is compliant with the Charter. And that means a provincial and a federal law, because both count as public action. But before you start saying that, for instance, an administrative decision maker has the power to apply the Charter, right, then you also have to subsequently assess whether the Charter applies. Not just whether the right's been infringed, but whether in the first place that right exists, because it only exists in your relationship to the state. And you have the test at page 79, which is helpful. We won't cover it directly, but it's helpful for what counts as an entity that is public for the purposes of applying the Charter. Because sometimes it's not going to be clear, right? Sometimes you'll have an entity that is public engage in actions that are not public. So, for instance, the government is going to buy paper clips for people who work for the federal government. In doing that, it's not subject to Charter review, even though it's public action. It's public action in something that is traditionally private, namely buying paper clips, and therefore that's not something that's subject to the Charter. And you have the test at page 79, which is basically going to look at how much of the action counts as public. So you'll have an assessment of whether or not it's a function that's traditionally been, quote unquote, pursuant to the McKinney case, a government function as opposed to a private function. And oftentimes you'll also have an assessment of whether or not the government has control over the entity. So the federal government can create some entity and say, we'll get away from Charter review by creating that entity. For instance, a hospital. Right? If the government has effective control, there's a strong relationship between the government and that entity, it's going to count as a public entity for the purposes of applying the Charter, which is all going to be relevant to assessing, again, the constitutional validity of something, which, as we said, is a determination that can also be made by